Namaskar. I'm Assistant Professor Kritika Dev from LG School of Law. Today we'll see Indian Evidence Act and of course a topic under this very act. And the topic is who may testify? The competency as to testify. When it comes to testifying, is everybody competent? And if yes, then are there any exceptions? And if there are any exceptions, then who are the parties who are falling under those exceptions? So let's quickly have a look at it. So here under this very heading, who may testify, we will see from section 118 to section 121 of the Indian Evidence Act. Now, when it comes to who may testify, the section says that all persons shall be competent to testify unless the court considers that they are prevented from understanding the question put to them because of all these reasons. Now, what are these reasons? Let's have a look. Now, the general rule here is that prima facie, every person is a competent witness. As we have seen under section 118, court believes every party or every witness to be a competent witness. But what happens when the court actually do not rely upon the statement given by the witnesses? What are those conditions? What are the conditions which are against this general rule? The general rule, as I said, states that prima facie every person is a competent witness. So when it comes to these very grounds of incompetency, now if people are falling under any of these categories, he might not be taken as a competent witness. Now the first one is the child witness. Now when it comes to a child witness is generally not being taken seriously. And why is that so? Because due to that very tender age, there are possibilities that the child might forget some basic and important informations, or might get afraid by seeing the accused if he is testifying against the very accused. There are other reasons as well because of the child and the level of understanding of the child. When it comes to their competency, it is being taken differently by the court. Then secondly, due to old age. Now when it comes to the old age people, they generally have the problem of, in general, in most of the cases, it is not applicable to everybody. As I always say, differs from case to case. So when it comes to an old age, in general, people are of a habit, they have a loss of memory, they cannot memorize things properly. So due to certain reasons, and in the old age, they are being they are being treated as an incompetent witness. Or if somebody was suffering from a disease of body or mind, right? If somebody gets periodical insanity or something like that, then that person cannot be relied upon. Or if that person had any sort of disease. When it comes to disease, the other parts of the body also does not work so efficiently as it does in the normal course of life or normal days, right? So because of disease of body or mind, then also if the person is suffering from that, these are can be taken as the ground of incompetency. Then cause of any other kind. Now if in a particular case there comes any other cause which the court finds to be very sufficient in order to declare a witness to be incompetent, then the court can do so under this very fourth heading. So here it was all about section 118. So now let's see what is section 119. Now when it comes to a dumb witness, a witness who cannot speak, now what will happen to them? Will they be termed as a valid witness? Let's see the definition. A witness who is unable to speak may give his evidence in any other manner in which he can make it intelligible, as by writing or by signs. But such writing must be written and the signs made in open court. Evidence so given shall be deemed to be oral evidence. So now here, the dumb witnesses are being taken as the competent witness. That is for sure, right? But now, if a witness cannot speak, what kind of evidence will be taken if it is given by a dumb witness? So here it is very clearly written under this section, if a dumb witness, of course, is unable to speak, and if he gives the evidence through writing or through any of the sign languages, then it shall be termed as an oral evidence here, right? So if you get any question that a statement or a dumb witness who's unable to speak, and if he through his gestures or sign, if he gives the evidence, what kind of evidence will that be? Then the answer will be very simple, that it will be a oral evidence, right? It will be termed as an oral evidence under section 119. Here, section 120 of Indian Evidence Act. Parties to civil suit and their wives or husbands. So when it comes to husband or wife of a person under criminal trial, in all civil proceedings, the parties to the suit and the husband or wife of any party to the suit shall be a competent witness. So when it comes to, earlier they were not being taken as the witnesses against each other, right? Husband and wife, because they were considered as two souls, one bodies, and many things like that. But with time, they were of course being treated as the valid witnesses against each other, and a husband can go, when it comes to a prosecution against wife, he can go as a witness, and when it comes to a vice versa situation, then the other spouse can go as a witness, right? And he will be, or she will be, a competent witness in that very case. Okay, now the section says judges and magistrate. Now, what will happen in the case of judges and magistrate? Will they be a competent witness? Let's see what the section says. The section says, no judge or magistrate shall, except upon the special order of some court to which he is subordinate, be compelled to answer any question as to his own conduct in court as such judge or magistrate, or as to anything which came to his knowledge in court as such judge or magistrate. But he may be examined as to other matters which occurred in his presence while he was so acting. So when it comes to a judge or a magistrate, they shall not be treated as a witness. But exceptions are also being given under the same section. Now, the first exception is that if there is a special order from a superior court under which that court comes, then they'll they will come uh, as a witness, right? Or if there is anything which has come to their knowledge during when he was present, or maybe some, if, for example, let's say if a murder took place in the courtroom itself. Now, that was not related to the proceeding. Now, in that case, the magistrate may go as a witness, right? Because that was not the part of that very case, and suddenly a murder took place. Maybe during outside the court or somewhere where he could see, where his vision was there. Then he may be called as a witness in that very case, right? So, with this, I guess everything when it comes to who may testify, we have seen that the general rule is every party is a competent witness. Every witness is a competent witness, but there are actually three things, but four is the additional. Anything can fit into that fourth thing, that the tender age, or maybe the old age, or maybe if somebody is sick by body or by mind, then they will not be termed as a competent witness. We have also seen that wife and husband, they could go as a witness against each other, right? They can appear as a witness and they will be termed as a competent witness. And now we have also seen that when it comes to judges and magistrate in general, they cannot be called, or they cannot be compelled to answer anything, whatever goes in their court related to that. But if there is any order by the superior court, then they will answer. And if something of other nature has occurred in their presence, so for that very fact, they may be called as a witness in that very circumstance. So by this, I guess everything related to the competency of a witness, and when they'll be allowed to give that very, when will they be allowed to testify, everything is clear till now. And this is for this very session. That is only just part one as in single session for this very topic, no part two, right? So with this, I would like to take your leave, and as I always say, keep revising, keep studying even after the lecture, so that you get a clear idea. And till then, kindly take care of yourself, and thank you so much for listening.